We are live. Good morning, everyone. Happy Monday. It's beautiful outside, so let's make today a beautiful Monday. All right, this is the 187 District Court. These are the rules. If you do not follow the rules, you will be required to appear in the courtroom. For all the inmates, you're not allowed to use the chat box. Do not use the chat box to speak to your attorney. Do not use the chat box whatsoever. If you use the chat box, you're going to be sent back to your cell. Do not use this as a avenue for you to pick up dates. This is not The Bachelor. This is not The Bachelorette. Do not try to pick up anyone for a date. If you do, you will be sent back to your cell. To everyone else who is at home or wherever you may be, you're not allowed to be in bed. You're not allowed to be cooking breakfast. You're not allowed to do any of that. If you do not behave professionally and appropriately as though you were physically in the courtroom, you will be required to appear in the courtroom. Please find a place to Zoom from and be stationary. If you move around, it makes everyone else nauseous. We're not filming and moving, so find a place, be stationary. To all the attorneys, if you have an agreement, no matter how small the agreement, you need to put it in the chat box to the coordinator. The court coordinator in this court is listed as Ferguson Coordinator. Do not text her. Do not call her asking for a reset. The only person who's allowed to give you a reset is me. The other thing, for all the attorneys in the 187 District Court, whoever appears first, that's the person who's going to go first. I'm going to open up the breakout rooms. The breakout rooms will invite you to a room. Do not go to a breakout room unless I specifically call your name and assign you to a breakout room. I'm going to call the names of the attorneys. To all the defendants, your name will not be called. If you do not hear your attorney's name, it's because your attorney is zooming in another courtroom. Rest assured, you will get a chance to see your attorney today and something will happen on your case today. So the order of attorneys: Colin Hobbs, Joe Richardson, Valerie Fisher, Miguel Nahara, Tilden Shaver, Vivian Casares. Did I miss anyone? All right, attorneys, if you need to Zoom to another court, you can. However, if you go to another court and your name has been called, you will be placed at the end of the line. The prosecutors have the ability to move throughout different breakout rooms. So attorneys, I will assign you to a room. Be patient into that, and while you're in that room, just consider that room sort of like when you go to your doctor's appointment, when the nurse calls you to the back and you think you're seeing the doctor, you're not. They're just putting you in a room to test you for your weight and your blood pressure. So just zen out in the room, and I promise you a prosecutor will meet you there. First person up is Colin Hobbs. Colin Hobbs, who do you have on the docket today?
Good morning, Judge. I have Gil Perez and Thomas Ryan, Your Honor.
Just 1 second. Is Gil Perez Family Violence or Criminal Trial Division?
It's CTD, Your Honor. He's actually on probation currently and is set, I guess, just for a status conference today. I think he requested to travel, so
I will look into that. And who's your other client?
Thomas Ryan, Your Honor. And that is going to be CTD. I worked with Marcus last week on it.
All right, what I'm going to do is I'm going to send you to breakout room number 1. A prosecutor will meet you to discuss both of those cases.
Thank you very much, Your Honor.
You're welcome. Joe Richardson.
I have Isaac Alcorta. We reached a plea bargain. I'm awaiting the paperwork. So if everyone can see the paperwork, I'll immediately fill it out. And then if I can be put in the Joe breakout room with him, I'll go through the paperwork with him and we'll immediately fill it out.
All right, is it criminal trial division or family violence?
Criminal trial division.
All right, I'll send you to breakout room number 2. To the state, are you aware of the plea bargain agreement?
Yes, Judge.
All right, and could you all make sure that Norma has the plea bargain agreement?
Yes, Judge.
All right, Joe Richardson, I'm assigning you to breakout room number 2. Mr. Alcalta, If you could go to breakout room number 2, please.
And have a good day, Your Honor. My friend is driving through Louisiana back from Mississippi, so he's going to tell me all about your great home state.
All right, it's God's country. So I'll send you to number 2, Joe. All right, Valerie Fisher.
Yes, good morning, Your Honor. I'm here for Glenny Hernandez, and I've been conferring with Joe Ray on this one.
And you say Lenny Hernandez?
Glenny
Hernandez.
Hernandez. Yes, Your Honor. Stephen Nicholas is also on this, but I don't think he's present yet.
Yes, he's here.
Oh, okay, great.
Yeah, I'm present.
Okay.
Thank you.
All right, I'm going to send you both to breakout room number 3.
Okay, thank you, Your Honor.
Miguel Nahara.
Good morning, Judge. I have Gavino Vara. It is an add-on for today. It was a motion to set bond.
Is it family violence or criminal trial division?
Criminal trial division.
All right, and it's Gavino. What's the last name?
Vara, V-A-R-A, Judge.
All right, I'll send you to a breakout room to discuss it with the state.
Thank you, Judge.
All right, I'll send you to breakout room number 4. Tilden Schaefer.
Good morning, Your Honor. I have Marquise Roberts. It's a criminal trial division, MTR and new NIMAG cases.
Did you say Marquise?
Yes, Your Honor.
How do you spell the first name?
It's a little different. It's Marquies, and then Jamal, Marquise Jamal Roberts. We had him under Jamal Roberts on your docket, I think, but it's Marquise, I believe, is his first name.
All right. I'm going to send you to breakout room number 5. A prosecutor will meet you there.
All right, thank you, Judge.
You're welcome. Vivian Casares.
Good morning, Your Honor.
Good
I
morning.
have Mark Ibarra, and this is for a PR bond hearing, I think. Norma had sent me, but I
Yes.
also was conferring with the state on his case, Judge.
All right. Is it criminal trial division or family
Yes.
violence?
It's a criminal trial division, Judge.
Okay. I'll send you to breakout room number 6 and a prosecutor will meet you there.
Okay, I was speaking with Marcus before, Judge. Was it breakout room number 6?
Yes.
Okay, thank you, Judge.
You're welcome. Are there any other defense attorneys remaining? All right, everyone, be patient. All right. Joshua Tellez, where are you?
Right here, Judge. How you doing this morning?
Oh, I'm doing fine. How are you doing?
I'm doing great.
All right, you're here for a compliance hearing.
Yes, ma'am.
What I'm looking at on the supplemental report are positive tests for cocaine and marijuana. Now, I don't know of any thing that you can take that will give a false positive for cocaine. So why is this happening?
Personally, I really don't know why I'm coming out for cocaine, because I can tell you, probation is one of the best things that actually happened to me. Like me going sober and continuing to be sober, I take pride in my sobriety, and this infuriates me just as much as it probably does you. So that's why I've requested for a hair follicle test so that I could prove to you that I'm actually not doing this, and I don't know how this is coming out.
So Rebecca, this is all for the patch?
I'm not sure, his officer, Ms. Chavez, is on. Maria Chavez.
All right, Ms. Chavez.
Good morning, Judge. How are you doing?
Good morning. Let me stop share.
Sure.
All right, Ms. Chavez. So what's going on with the UAs
So
and with the patch really?
on the patches, yes, they are coming out. The results have been coming out positive for cocaine and marijuana, and I've spoken to Mr. Chayes before about it. Again, he tells me up and down that he has not used cocaine and marijuana, that he hasn't really used that either. He has on his own accord gone for drug tests because he stated that he wanted to make sure that, you know, the court was aware that he was not using. And that's why you see some of those UAs. Those were not any that I sent him to. Those were something that he was going to, like I said, on his own accord. But the patches are coming back. The reports do state that there is, you know, cocaine and marijuana in his system. I'm not sure how, you know, how we can otherwise, I guess, you know, confirm that, because I'm not sure. I haven't been able to call the lab to see if they can confirm a drug patch, but I don't think they can as well as they can confirm the UAs. But that's why he had informed me about the hair follicle. I said, that's fine. I will bring it up to the judge and see what she wants to do in regards to that.
All right. So, Mr. Tellez, I appreciate your wanting to do the hair follicle, but the hair follicle is not as nice and pleasant as people think it is, because they're taking hair from the root. And so it's painful. So here's my question. Are you employed?
Yes, ma'am.
All right. What are your work schedules?
Mostly early in the day. Like I usually get off by like Monday through Friday, like before 3.
All right. Are you off today?
I indeed am.
All right. So this is what we'll do today. Today we'll have Mr. Tellez go take a UA.
Okay.
All right. And the reason, Mr. Tellez, I have you on patches is because my understanding is that your schedule is very busy, and patches are easier than probation calling you for a random UA. But it appears that we may have to do UA. So let's do a UA and let's see what the results are.
Okay.
All right. So I'm going to want him to do a UA today. And then if that UA is positive, then we can send it off for a confirmation. And Mr. Tellez, the confirmation, you're going to be responsible for paying for that. You understand?
Most definitely.
All right. So I'm going to send you to a breakout room with probation. And they'll tell you where to go to complete the UA. Mr. Tellez, is there any other issues with your probation that you want to discuss?
No, I've actually been doing very well. The only thing that's concerning me is the drug patch, and that's it. Other than that, I've been doing fine. I've been paying my bills and everything.
All right, that's good.
And he does report, Your Honor, every Zoom meeting that I do have him come in, and those are, you know, I schedule him on different days so that he doesn't get, you know, complacent on a specific one, which he doesn't have an issue with. So he has been reporting. He is attending outpatient. But the only thing with the outpatient too, while we're on here, I did want to bring up, because of the fact that he has come out positive on the drug patches, I'm not sure how they're going to deal with him in regards to possibly exiting him, because they do exit them because of the fact that if they come out positive, they have a diluted, etc. I just want to make the court aware that I'm not sure what's
all right. Can you contact them and let them know I don't want him exited yet? Okay. We're going to try to figure out what's going on with the patches.
Yes, ma'am. I will do so.
And so what we're going to do from now on then, we'll do random UAs, but can you keep in mind his work schedule?
Oh, yes,
I think you can still do random, yet take in consideration his work schedule.
Yes, ma'am. Do you still want him on a weekly, or can we put him back on monthly reporting?
Well, let's see how the UA turns out. Okay. And then if the UA is negative, then I'll just send me something and I'll make a determination on how I want him to report. But for now, let's keep everything the way it is until we figure out what's happening with the UAs.
Okay, sounds good. So right now, hold off on the hair follicle.
Yes.
Okay. All right, ma'am. Sounds good.
Sure. All right. I'm going to send you all to breakout room number 7. And then Mr. Tellez, you're excused. Thanks for coming in.
Thank you for having me.
All right. So I'll send you all to number 7.
So then I do join number 7.
Yes. Go to breakout room number 7.
All right. Thank you. Have a great day, Judge.
All right. You too. Thank you.
Thank you, Judge.
And Rebecca, do you need to go there or no?
No.
Okay. Miguel Nahara, you're back.
I am back, Judge. And a little history on this case. And Mr. Vada's bond was originally set at 125. I ended up having a hearing in magistrate's court. Judge Carruthers lowered it to 100. And I don't remember at that point if a full house arrest GPS was already a condition or he added it at that time. I don't recall, but it was a condition. At some point after he made bond, I guess probably a few months later, I filed a motion to amend his bond to allow for a partial house arrest, which you granted. I've conferred with Tom Nisbet. He is agreeing to reinstating the $100,000 bond, Judge, although he's asking for a full house arrest at this point without any ability to leave, to make sure he's compliant for some time before I reapproach the court with any sort of modification.
All right, and is that agreed to?
It is, Judge. Tom, you're muted.
That is a very tidy synopsis of our discussion.
Okay. All right, to the clerks in the back, could I have a B page, please, on 2019 CR 11408? So it's agreed reduction or reinstatement of $100,000 bond plus full GPS.
Correct, Judge.
All right, I'll waive the GPS fees and put him on the indigent list. However, the court does not have any authority to waive GPS fees, but I'll write it down anyway and see what happens.
Thank you, Your Honor. I appreciate that.
Sure. Is there, do you have anyone else with us on the docket?
I don't believe so, Judge.
All right, and Mr. Vera, do you need to confer with Mr. Vera? He's on the screen.
Sure, I'll talk with him briefly, if you'll allow me, Judge.
Yes, and then when you finish talking to him, if you could please have him come back to the main room so we can release him.
Certainly, Judge.
All right, if you go back to breakout room number 4, Mr. Nahara, and Mr. Vera, I'll send you to breakout room number 4. And everyone, just give me a moment.
And Judge, when you can you please put Glenny Hernandez in breakout room 3 with his attorneys?
Is he in custody? Yes, 14C.
Yes, he should be.
And you say number 3?
Yes, Judge.
Mr. Hernandez, please go to breakout room number 3, please. Yes, for Vera. Yeah, that's what I did. Everyone, just give me one moment, please. Mark Jarling, you here?
Good morning, Your Honor.
Good morning. Who do you have?
Daniel Guerra. If possible, I'd like to talk to a prosecutor. I visited with him. I have an idea, but
Is it a criminal trial division or family violence?
Criminal Trial Division.
All right, I'll send you to breakout room number 8. A prosecutor will meet you there.
Okay, thank you.
All right, Miguel Nahara,
Yes,
if
Judge.
you can
I
make sure your client comes back to the main room. He's still in number 4.
told him to, I guess maybe he didn't know how to. Let me go back and tell him again, Judge.
All right, thank you. Tilden Schaefer.
Judge, I need to speak with my client. I've got a plea offer, and I'll put that in the chat to Norma.
All right. Jamal Roberts. If you'll go to, let me see, breakout room number 5, please.
Judge Boyd, I'm sorry, kick me back into the mean. May I be excused?
Yes, thank you.
Thank you, Judge. Have a good morning.
All right, you two, everyone give me a break, please.
Okay, Judge, my client should be back. May I be excused? Oh, he just,
Just give me one moment, Miguel.
sir, I apologize, Judge. I didn't realize you jumped off.
Miguel, can I talk to you in a breakout room when Judge gets back, please?
Of course. Do you want me to go to 4? That's the one I'm assigned to already.
Yes, sir.
All right, Stephen Nichols.
Judge, can you send me to 4 with Miguel Nahara real quick, please?
Yes.
Thank you.
Just looking for JR.
Yep, I'm here. Do we need to go in a breakout room?
Yeah, if we could real quickly.
All right, I'll send you to breakout room number 9. Stephen, does the other attorney need to go to number 9 as well?
I think she's going to wait for me to come back because.
All right. I've sent you to the breakout room number 9.
Number 9. Thank you, Judge.
Mm-hmm.
And good morning.
Good morning to you too. Eric DeWalt, who do you have?
Good morning, Your Honor. I'm in the 226, but I'm logging on. I got an email at 9:15 saying that Mr. Conkey was set today. I have him set for April 22nd, but I'm logging in just so we don't miss anything.
All right, yes, he's requested a PR bond. That's why you're here.
Gotcha.
All right. And is he criminal trial division or family violence?
You asking a prosecutor?
No, I'm asking you, is he charged with something that's family violence or criminal trial division?
Let me look him up.
Or is it special? Because one is impersonating a public servant.
There's one.
What's the name? I can find out if it's a special prosecutor.
It's Christopher Conkey. And Miguel Nahara, you're back.
I am, Judge, and we have finished conferring.
All right, where is this case headed?
Mr. Vada?
Yes, because there are I see there are no more discovery issues.
No, we're just waiting on trial date, Judge. I think we've done the discovery acknowledgement. We've conferred a ton. It's just unfortunately one of those cases that's most likely going to have to be decided.
Okay, so what I need to do then is I need to give you a plea deadline date because I haven't given one in this case.
Sure,
Norma
Judge.
Ferguson,
Yes, ma'am.
can you recall Mr. Vera in 30 days?
Yes, ma'am.
Norma, will you be sending me a setting through the email?
Yeah, I can give it to you right now.
Perfect.
You will call him back on May 6th.
All right, so May 6th will be your plea deadline date.
And Your
Got it,
Honor, if I
Judge.
may, sorry.
Oh,
Just one
may I be
moment.
excused, Your Honor?
Yes, you're excused.
Thank you, Judge.
Your Honor, this is Mr. Twalt again. I'm showing that I was appointed to represent in possession with intent to deliver penalty group 1, 4 to 200. And then the other two are older cases. So I would assume they're W cases. I would assume he has 2 MTRs with this new number 1.
That is correct, Judge. The new offense is CTD because one of the other offenses is in that special unit, public integrity. I'm contacting them to see if they want the MTR, if they want us to handle it. So I'll check back in just a minute.
All right, thank you. And then we'll address the PR bond issue.
Thank you, Judge.
You're welcome.
Judge, do you have a minute?
Yes.
Mark and I are back on his client, Daniel Guerra.
Yes.
It's a motion for a PR bond. I was looking at his history. He has assaultive history. So I don't know if he's qualified. It's an injury.
All right. And that is Guerra, correct?
Yes.
Let me find the PR bond sheet. All right, the PR bond that I have on Daniel Guerra, it shows the injury to the elderly. So Mark, Mr. Guerra, where are you? Yes, could you unmute, please? Mr. Guerra, based upon the governor's directive, you are not eligible for a PR bond because of violent history. Do you understand?
Yes, ma'am.
All right. And state, do you have an idea when you'll have the laboratory reports on his case?
Your Honor, this case, I think it's from the 10th of this month. So I would anticipate probably not for another 2 months.
Okay. All right, then, if there is nothing else, Mr. Darling, anything else?
Well, no, because as you know, Your Honor, the state's not negotiating cases without a lab report. So I don't think even if we wanted to, we'd be able to resolve it.
No, would you like to?
I mean, I would like.
Would you like to speak with your client?
Well, yes, please. Yes.
All right, and once you speak with your client, Mr. Darling, if you could bring him back to the main room so he can be excused. All right, so.
Yes, I will, Judge.
And if you, Mr. Darling, if you'll go back to breakout room number 8, and Mr. Guerra, if you'll go to 8, please.
Thank you.
Your Honor, if I may, I'm in the 226. I'm about to do a sentencing. Can I log off and come right back?
Yes.
Thank you much.
Yes.
I'll be right.
And to the clerks in the back, do you have all the paperwork on Isaac Okolta?
Not yet, Judge. I'm waiting for the plea packet to come in so I can swear him in, and then we should be ready to go.
All right, Joel, did you complete the plea paperwork?
Yes, but I wasn't sure about the waiver and all that. I'm not sure that was sent to me by Marcus. I think Marcus was working on it, but I wasn't sure if he sent it to me or not.
All right, because the court doesn't have any plea paperwork.
I was there with him. He had one last paper to fill out. I filled out three papers and had him send it. I was there when he clicked the send thing, but I think we were still missing some paperwork. But I'm sure Marcus will send it to me and then I'll immediately go back to the breakout room too and fill it out with him.
Okay, great.
We're well on our way here, so.
All right, who's the attorney for Gilbert Perez?
That's Colin Hobbs. He's in a breakout room.
See, Marcus, I'll go back to breakout room 2 if you want me to go there. If you want to see me, I'll be in breakout room 2. Is that okay?
Yeah, it should be coming your way soon.
Okay, thank you, Marcus. Hope you're having a good day today. So.
Thanks, you too.
This may be one of the few things I'm doing this week. This week has nothing going on for me.
Yeah.
Judge, I wanted to go to the casinos in Louisiana, but my friend didn't want to meet me at the casinos there in Louisiana. So I think there's one right on the border there.
Oh, hey, you know, everything happens for a reason.
They have horse racing too. I'll even try to see which horse is the best.
Okay.
Is that Churchill Downs? I think that's a name or something. I don't know.
Yeah. Well, we have Louisiana Downs.
I think that's it. Your Honor, I'll go back to the breakout room 2. We're well on our way, and I'll immediately send something in chat if I think we're ready.
All right, thank you.
Thank you.
I got the sauce.
Just unmute your mic.
Mr. Ibarra?
Yes, ma'am.
Hi, you're not to provide assistance to other inmates because you're not allowed to communicate with other inmates, okay?
Yes, ma'am.
And you need to put on your mask. There's something going on that's called COVID-19 and whatever its variants are. All right, Colin Hobbs, you're back.
Yes, Judge.
Yes, what the other client you had was Thomas Ryan?
That's correct. I think Marcus and I are waiting for a waiver number so we can start getting paperwork together on that.
All right, great. If you guys will let Norma know what the agreement is on that one. And then on Gil Perez, were you able to confirm that?
Yes, Your Honor.
All right, so he has a request for travel?
That's correct, Your Honor.
And is there an agreement or no?
It's a special crimes case, so I'll reach out to Dawn. It doesn't seem like she's in agreement. Her concern is that because there's still a good amount of restitution owed, that she doesn't feel he should be taking a vacation to Vegas.
Well, I guess the question would be, is it already paid for?
Gil, do you know how to unmute yourself? Have y'all already purchased the tickets, everything like that? Gil, can you hear me?
Mr. Perez.
Yes, I can barely hear you.
All right. Why are you going to Vegas when you owe all of this money?
Ma'am, I'm sorry. I hit unmute. I don't know if you can hear me.
Yes, I can hear you.
Judge, if I may, since he's having trouble hearing us, he and his wife got paid a bonus late last year. They very much tightened their belts over the course of this probation. He is current with his restitution. He has made payments every single month on it. And it's just the fact that, you know, everyone's kind of been stuck doing not much. I believe that they're going to be vaccinated. They're going to be safe in Vegas. My client does not drink at all based on the fact that he has diabetes and it could be a health hazard. I think it's just strictly his wife got a bonus late in the year and they wanted to do something nice for their anniversary, but he very much intends to keep paying. He's not behind at all. So I would hope that the court would take that into consideration. I know that probation is not supposed to be a vacation, so to say, but I don't know that there's any bar from someone taking a probation or taking a vacation while on probation. I know he has a lot of restitution still due, but he is making those payments religiously, Your Honor.
You know what I failed to understand? Now, mind you, I realize this is not his wife's debt, but I don't know why he wouldn't say, instead of me taking this trip, because I still owe $118,000 in restitution, instead of traveling to Vegas during a pandemic, why don't we put this money towards what I owe?
Ma'am, may I speak?
Of course.
I'm 65 years old. I know I did a crime. I had a choice between pleading no contest or guilty. I pled guilty. It's at 65 years old. I never knew how this would affect me in the sense that, one, I lost my daughter. She was in the city of San Antonio growing up, and I brought the shame upon her. It's been 4 years, and she's now working in Korea. I was thinking and trying to make restitution. I had always thought of retirement. I took my Social Security benefits sooner so that I could guarantee whatever agreement had come up with. And so I lost $500 a month if I would have waited until I was 65 to take my Social Security benefits. I thought of that because I wanted to make restitution. I had no problem with that. I realized I lost my right to vote, and that hurt. I also, more than anything else, is I just recognized who friends were and who were not, because it's like, because of the shame that I brought upon my family, upon myself, it's like they were really acquaintances who I thought were friends. But I think the most important thing is I'm a convicted felon, and I don't think any amount of lecturing, and I don't mean this in a bad way, Judge, but no amount of lecturing can do what I do to myself each night when I go to bed. I remember I'm a convicted felon. I wake up, I'm a convicted felon. And it's something that hurts. But one of the things, after being married for 30 something years, it's like we were looking at retiring, at traveling. I've tried to do, I've made every effort to be in compliance, because I know that I'm a ward of the legal system of you, for example. You can make the decisions, but I know that if I screw up, I go to prison. I don't want to go to prison. But I see my wife, who has stood by, and yes, but I don't want to take her money that she's worked for, as far as she got a bonus. And we had always traveled throughout the United States for many years since we first got married. And she wants to go, but she wants me to go as well. And so I don't have any other reason than that. It's like I'm taking responsibility. I'm complying with everything. And like I said, it's yes, it can be seen in that manner, but I don't want to deny her either for my screw up. And I can't explain it any better, man. And so, yes, I know, I realize that I'm no longer a free person. I know that I've had job opportunities, but I'm good at what I do. But the problem, when I tried to get probation, they explained I cannot go out of state without the judge permission. The problem is that the job offers that I had, where I'd start off at 48, 50,000, I'd have to go out of town like within 2-3 hour notice, because I'd be a troubleshooter. So I know I screwed up. I lost those opportunities. And I've made every effort to comply with everything that the court has asked me to. I have no other reason, man. I can't give you any other, I beat myself every day. And it's not so much, we've always enjoyed what shows that were there. We always enjoyed eating. So it's not like I'm rich. 70-something% of my Social Security check goes toward restitution. I get paid on the third Wednesday of the month, other than February, because of the storms and the probation office was closed. I go personally and I make the payment in person there at the South Cross Station, for example. So I take that very seriously. That's all I can say, Judge.
And Judge, just to add two things, what he was explaining about his daughter, I think he explained it, but maybe not quite well enough. When he says that he has lost that relationship, she very much kind of cut him off out of his life and literally moved to another country to separate herself from the media scrutiny involved in this case. To say that he has been punished, he has been. He tortures himself, quite frankly. And Judge, I don't like to broadcast this on YouTube, but when Gil called me freaking out last week because he didn't know that what was happening with this case and why it was set, I didn't even charge him. for this. He is a client that, to a degree, I connected with over the course of our representation. He knows that he messed up, and he has truly tried to take responsibility in this. And I would hope that the court allows him, even if the court wants to put a no gambling while you're there, no drinking while you're there rules on him. I'm not sure how to enforce that. Don't get me wrong, but he is
Oh,
terrified.
no, he's not supposed to be drinking on probation at all.
And he's not, Your Honor. and he can't because he has diabetes, like severe diabetes, to the point where drinking can really mess up his blood sugar. So I'm just trying to think of ways to, to assure the court that it is just a trip for he and his wife to, even though they've not been able to do so for a couple years now, to do something nice for themselves.
Probation, is he current with his restitution payment plan?
Yes, ma'am. It shows that he's been consistent in making his payments.
All right. And state you're opposed, is that correct?
Sorry, Judge, what'd you say?
And the state is opposed?
Yes.
All right. To the clerks in the back, could I have the B page on 2017 CR 7374, please?
Yes, Judge.
All right, Mr. Pettis, I'll allow you to travel within the COVID guidelines, and you're to do a UA upon return.
Thank you, Your Honor.
You're welcome. You need to continue to stay up and continue to do what you are supposed to do on probation, okay?
Yes, ma'am.
All right, if there's nothing else on Mr. Pettis, then he's excused.
Thank you, Your Honor. Gil, you can go ahead and leave. I'll call you later today.
Thank you.
Thank you. Thank you.
All right, Mark Darling, you're back on GARA.
Yes, Your Honor. I think we've done about as much as we can do today. So, you had pursuant to the governor's order, you can't give them a PR bond, which I understand. So, since there's no lab result, I don't know that we can go forward, and Miss Williamson is not making an offer for that reason. So, the case is indicted. I don't know what to do.
All right, if at any time you would like to request a bond reduction, just let the court know. All right,
well, Judge,
and, yes.
Would you entertain that now, or do I need to file a motion for that purpose?
Well, it depends on if the state has any objections, because since it's not a written motion, it would just be an oral motion.
That's fine, Your Honor.
All right, have you all had a chance to confer?
We have.
All right, just give me a moment. All right, to the clerks in the back, could I have the B page on NIMAC number 605615, please? All right, state, are you in agreement in a bond reduction or no?
No, Your Honor, the state believes that $3,000 is appropriate in this case. He actually is a repeater, and this would be a second-degree felony based on that enhancement. Normally, I would say that it's probably actually pretty low for that.
All right, and we're not on the record yet. Defense?
Well,
are you going to call witnesses?
No, Your Honor. Would you like just to hear argument, or?
Yes, let me go on the record. Just give me a moment, please. Brenda, you ready?
I'm ready.
All right, the court is calling NIGHTMAG number 605615, State of Texas versus Daniel Christopher Guerra. I'm going to have parties announced for the record, please, for the state,
Alexandra Williamson.
for the defense.
Mark Darling.
And are you Mr. Guerra? If you could unmute for me, please. Are you Daniel Christopher Guerra?
Yes, ma'am.
All right, we're proceeding by video because of the pandemic. Any objection from the state?
No, Your Honor.
Any objections from the defense?
No, Your Honor.
Mr. Guerra, do you have any objections to this hearing taking place by video?
No, ma'am, not at the moment.
All right. And the defense has an oral motion for bond reduction. The court has denied the motion for a PR bond based upon the governor's directive and the defendant's criminal history. Is there any objection, state, to proceeding with the defense's oral motion for a bond reduction?
No, Your Honor.
All right, his bond is currently set at $3,000 for possession of a controlled substance, penalty group 1 gram to 4 grams. State, are you in objection to reducing the bond?
Yes, Your Honor.
And why is that?
Your Honor, this, as it's awaiting indictment, so we don't actually know the weight of the drugs at this moment, but based on his history and this level offense, it's actually going to be, I anticipate that it'll be enhanced to a second-degree felony. And so I think $3,000 is appropriate.
Defense?
Well, Judge, if you consider the charge in the context of the felony bond schedule, you know what Ms. Williamson said certainly is true. And but I would assert to the court that but for the governor's order for this type of nonviolent offense, something like this would qualify for a bond reduction based on the nature of the alleged offense, just possession of a controlled substance. And I would also let you know that, well, Mr. Guerra can't afford a $3,000 bond, but could make a bond in the amount of $1,000. And when I say that, we have a cousin that may be able to assist in that regard. It's been a while since the case that may be made basis of the enhancement if this thing winds up being indicted and stuff. So it's obviously can't make bond. He's been in there a while at 3,000. So respectfully, we're just asking for the bond to be reduced to 1,000.
All right, the court will deny the motion, the oral motion. Mr. Darling, if you want to file another motion for the court to reconsider in 30 days, and the court will of course be open to reconsidering.
Okay, I'll reach out to this relative and keep working on it. And as we discussed, Mr. O'Gara, may then I be excused, Judge?
Yes.
Okay, y'all have a nice day.
All right, thank you. Norma, can you let them know that Mr. Guerra can be excused? He's 16E.
Yes, ma'am.
All right, Children Schaefer, you're back.
Yes, Your Honor. I just need to finalize something with Jordan, but I think yes, we have a deal, Judge, so we can proceed.
All righty, if you'll put in the chat box to Norma Ferguson what the agreement is.
Yes, Your Honor.
Thank you. Johnny Gonzalez. If you can unmute for me, please. Norma, can you have somebody help Mr. Gonzalez unmute?
Yes, ma'am.
He's 17J. And to the prosecutors, criminal trial division, on Mr. Gonzalez's case, do you have any idea when the laboratory reports will be ready? He's on the recall docket. He's listed as Johnny Gonzalez.
Right here.
All right, Mr. Gonzalez.
Yes, ma'am.
All right, are you able to hear me, Mr. Gonzalez?
Yes, ma'am.
All right, Mr. Gonzalez, the court is in receipt of your application for a PR bond. You do not qualify for a PR bond because of the governor's directive. I know your charges are from 1987, but what I have is that you went to prison for aggravated robbery for 45 years and attempted murder. Are you that same person?
Yes, ma'am.
All right, so you're not eligible for a PR bond, okay?
Yes, ma'am. Can
Right,
I say
so
can I say something?
If it's about your cases, no, because
No.
your attorney's not here, okay?
Okay.
All
so,
right. State, do you have any idea when his laboratory reports will be ready on the drug case?
Judge, I would say at least 3 weeks. I have a case that's 20 days newer and I don't have labs yet, so probably 3 to 4 weeks would be a minimum.
All right, Mr. Gonzalez, we'll bring you back in 3 to 4 weeks to see if the laboratory reports are ready, okay?
yes, ma'am. So I can't say nothing at all.
Just 1 second. Norma, can you see if his attorney can zoom in? James Anders, please.
Yes, ma'am.
All right, I think you should wait until your attorney appears. So your attorney will zoom in, okay?
Thank you.
Judge, can I see you in a breakout room really quick?
Yes. You want to meet in breakout room number 5?
Yes, please.
Well, you're in 7. I'll join you in 7.
Okay.
All right. Everyone, just give me a moment. All right, Tilden Schaefer.
Yes, Your Honor.
Hi, what is happening with your client?
Judge, we've reached a plea agreement. My client it's going to be an open plea. He's going to plead true to the number one. And then this state agrees to TIC.
Oh, just put it in the chat box to Norma Ferguson, the court coordinator, so she can get the paperwork.
Okay, I did, Judge. So we're just waiting on that then. I already did that. Thank you.
All right, so Tilden, if you will go back to breakout room number 5, and Mr. Roberts, if you'll go back to number 5, paperwork will be sent to you.
Judge, that paperwork has been sent. It's been sent. It's been in his email for a while.
Okay, I responded about 5-10 minutes ago, so I'll go back to 5, Judge.
All right, thank you. And Mr. Roberts, can you go to 5? And Mr. Schaefer, if you can make sure that your client has signed the paperwork.
Yes, Your Honor. Thank you.
Thank you. Vivian Casares, you're back?
Yes, Judge. I was waiting to see, my client hasn't come in yet, Mark Ivara, into the breakout room to go over his paperwork.
Okay, Mr. Ibarra, I'm going to send you to breakout room number 6. If you'll go there, please.
Okay.
Mr. Roberts, could you go to breakout room number 5, please? Unmute yourself.
How do I do that, ma'am?
All right, do you see at the bottom where it says breakout rooms?
Okay. Okay, thank you.
Yes. Just click on that and go to the room.
Smashing my hand, tried twisting my arm. I stabbed him. They cut someone's finger off with a damn chainsaw. I'm not gonna be a dick. Yeah, the same trace slot they were slamming on my hand.
Thank you.
Trace slot. There's a hole in our door where they beat us through.
James Anders.
Yes, Judge.
Hi, I'm going to send you to a breakout room with your client, Mr. Johnny Gonzalez. There was a request for a PR bond, but he's not eligible because of his criminal history.
Okay.
So I will send you to breakout room number 2. And when you finish speaking with your client, if you could return to the main room. Mr. Gonzalez, you're being sent to breakout room number 2. And Vivian Casares, you're back?
Yes, Judge. He hasn't gotten his paperwork emailed to him at the jail yet for him to sign.
Did you sign yours?
I did. Yes, Judge.
All right, it should be going to him then.
Okay, I'll go back. Thank you, Judge.
All right, thank you. All right, we're proceeding on Alcorta. Who is the prosecutor who's on Alcorta?
I can do it, Judge.
All right.
We're all ready, Judge.
All right, Mr. Alcorta, if you can unmute for me. Mr. Alcorta, if you'll look, there's a request that says unmute. All right, thank you. Court is calling 2021 CR 0387 and 2021 CR 2316, State of Texas versus Isaac Jacob Alcorta. Can I have parties announced for the record, please, for the state,
Marcus Sanders.
for the defense?
Joel G. Richardson.
And are you Mr. Alcorta?
Yes, I am.
We're proceeding by video because of the pandemic. Any objections from the state?
No objection.
Any objections from the defense?
None, Your Honor.
Mr. Alcorta, in each of these cause numbers, I'm showing you documents entitled defendants consent to appear by video. Did you review those documents with your attorney? Did
Yes,
you
Your Honor.
understand them? And did you electronically sign them in both places?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Counsel, I'm showing you documents in each of these cases entitled Discovery Acknowledgement. Have you received all the discovery in each of these cases? And did you review that discovery with your client?
Yes, ma'am, I did.
And each of the cause numbers, the court will find that the state is in compliance with discovery. Mr. Alcorta, in each of these cases, I'm showing you what's entitled True Bill of Indictment. Did you review those documents with your attorney? Did you understand them?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State and cause number 2021 CR 0387. Are you proceeding on both counts?
No, we are proceeding on count one, waiving count two.
Any objections?
No objections, Your Honor.
And in cause number 2021 CR 2316, are you proceeding on both counts?
No, we are proceeding on count one, waiving count two and the enhancement paragraph.
Any objections?
No objections, Your Honor.
Mr. Alcorta,
Yes, Your Honor.
and cause number 2021 CR 0387, you're charged with the offense of theft, 2,500 to 30,000 of a vehicle. And in cause number 2021 CR 2316, you're charged with theft, 2,500 to 30,000 of a vehicle. Each of those charges are state jail felonies. The range of punishment in each of those cases are anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow the plea bargain agreement. If for any reason the court does not follow the plea bargain agreement in each of these cause numbers and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
In each of these cause numbers, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand?
Yes, Your Honor.
Did you understand by entering a plea bargain agreement in each of these cause numbers, you're giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into plea bargain agreements in each of these cause numbers?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses in either of these cause numbers?
He certainly has.
Do you believe he has a rational as well as a factual understanding of the charges against him in each of these cause numbers?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense in each of these cause numbers?
Yes, I do.
Mr. Alcorta, in each of these cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter a plea?
No, Your Honor.
And each of the cause numbers, has anyone promised you anything other than the plea bargain agreement to get you to enter the plea?
No, Your Honor.
And each of the cause numbers, are you satisfied with the way you've been represented?
Yes, Your Honor.
And each of the cause numbers, are you a U.S. citizen?
Yes, Your Honor.
And each of the cause numbers, the court will find that the defendant has knowingly and voluntarily waived his right to jury trial. And each of the cause numbers, I'm showing you the plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, Your Honor.
And each of the cause numbers, the state is proceeding on count one. They're requesting that your punishment be assessed at 18 months in the state jail facility. There are no applications for community supervision or deferred adjudication. The cases will run concurrently. and the state will take in consideration NIMAG number 566638, JN number 2005521. Did you understand that to be the plea bargain agreement in each of these cause numbers?
Yes, Your Honor.
State, is that the plea bargain agreement in each of the cause numbers?
Yes, Judge.
Defense, is that the plea bargain agreement in each of the cause numbers?
Yes, Judge Boyd.
Mr. Alcorta, in each of the cause numbers, I'm showing you the paragraph entitled Waiver of Appeal. Did you review that paragraph with your attorney? Did you understand it, and did you electronically sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such cases?
No, Your Honor.
Then Mr. Alcorta, and cause number 2021 CR 0387, how do you plead to count one? Guilty, not guilty, or no contest?
No contest, Your Honor.
And in 2021 CR 2316, how do you plead to count one? Guilty, not guilty, or no contest?
No contest, Your Honor.
State, do you have any evidence to support the defendant's no contest plea in each of these cause numbers?
Yes, the state offers State's Exhibit 1 and its attachments for each case separately.
Any objections?
None, Your Honor.
Mr. Alcorta, in each of these cause numbers, I'm showing you documents entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review those documents with your attorney? Did you understand them, and did you electronically sign them in all the appropriate places?
Yes, Your Honor.
Again, did you understand in each of these cause numbers, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in each of these cases in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
In each of the cause numbers, the court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same.
Yes, Your Honor.
All right, in each of the cause numbers, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty of count 1 and each of the cause numbers. Are you proceeding with sentencing?
Yes, Your Honor.
Is there anything you wish to say on behalf of your client?
He's been very cooperative and respectful. He wants to pursue his educational technical training at the state jail. He wants to take a drug course. He says he wants to be a drug counselor when he gets out of state jail. I just think he has a lot of opportunities here, and I told him that if anything else happens, it'd probably be a 3rd degree or higher next time. So he really wants to stay out of trouble.
All right. In cause number 2021 CR 0387, the court will follow your plea bargain agreement, sentence you to 18 months in the state jail facility. This will run concurrent with 2021 CR 2316, taking consideration NIMAC numbers 566638, JN number 2005521, and give you credit for any time served. And cause number 2021 CR 2316. The court will follow your plea bargain agreement, sentence you to 18 months in the state jail facility. This will run concurrent with 2021 CR 0387. Take in consideration night mag number 56638, JN number 2005521, and give you credit for any time served. Is there anything else from either side with regards to sentencing?
Nothing further, Your Honor.
Mr. Alcorta, in each of these cases, I'm showing you what's entitled trial court certification of defendant's rights to appeal. Did you review those documents with your attorney? Did you understand them? And did you electronically sign them?
Yes, Your Honor.
All right, because this was a plea bargain agreement that was reached in each of the cause numbers, because I followed your plea bargain agreement in each of the cause numbers, and because you waived your right to appeal, you do not have the court's permission to appeal in either of the cause numbers. Do you understand?
Yes, Your Honor.
And because these are felony convictions in each of the cause numbers, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, Your Honor.
All right, Mr. Corta, good luck to you. We can go off the record, Brenna. Mr. Corta, if you have any type of drug issues, there are plenty of programs that are available for you inside the prison system as well as outside the prison system. Do you understand?
Yes, Your Honor.
All right, no more stealing. Do you understand?
I do, Your Honor. Thank you.
And the good advice for you that I can give you, don't hang out or associate with people who don't give real names.
Thank you, Your Honor.
And their name, Rich Boy. Maybe that's what he aspires to be, but probably if he were a rich boy, he wouldn't be stealing, okay?
Yes, Your Honor.
All right, good luck to you. Norma, can you let them know that Mr. Alcorta can go back? He's L4.
Yes, ma'am.
Thank you, Judge. May I be excused, Your Honor?
Yes, have a good rest of the week, Joel.
God bless you. And I really wish I could go to that casino in Louisiana. I want to, but my friend doesn't.
Okay, your friend may be saving lives by doing that. So just say thank you because everything happens for a reason, okay?
And if you want to take friends, I'll be more than happy to go with you.
Okay.
I can't guarantee we'll win money, though. I'm sure I could go either way, but most of the time I'm optimistic.
Okay. If only I gambled. I don't, so.
I get a lot of free hotel rooms and free food, but don't come home with much money in my wallet.
All right, have a good one.
You too. Bye.
Bye-bye.
Besties.
All right. There should be some documents coming to the back of Mr. Roberts. And there should be a plea packet on Ibarra. So if someone could swear Mr. Ibarra in, please.
Will do, Judge.
All right, Stephen Nichols, you're back on Hernandez.
Yes, I just needed to ask JR a couple of questions. I've done that. And could I be sent back to the room, or I don't remember what number I.
Oh, no, I sent you back to the room after you had spoken to them. So let me find it here. Yes, if you can go back to number 3 now. That's where you're stationed.
Okay, what room?
Number 3, if you just click on the box that says breakout rooms, it'll show.
Yeah, thank you.
All
Number
right.
3, it's number
3. Well, felony court graduations is at 1 p.m. today on YouTube. Let me see if I can find it. Let me share screen. So, Brenda, it's today at 1 p.m. And the 187 District Court, we have 13 graduates in felony drug court.
Wow.
Yes, so it's like they're going to be clean and sober. Of course, you know, I love this program.
Yeah.
So anybody who wants to watch it, that's the YouTube link to watch felony court graduation from drug court. All right, children, we'll take your client up next. I'm just waiting for them to bring me the paperwork.
Thank you, Judge.
Judge, this is James Anders. I'm back from speaking with my client.
Okay. Norma, can you let them know that Mr. Let me see what room you were in. Can you let them know that Mr. Gonzalez can go back? He's 17J.
Yes, ma'am.
All right. Mr. Anders, thanks for buzzing in. Do you
Okay.
have anyone else with us?
I don't believe so.
All right, so they're telling me that the laboratory reports on him should be in probably in 3 weeks.
Okay. Hopefully e-discovery will be working again in 3 weeks.
Oh, e-discovery is not working?
It was having trouble over the weekend and earlier this morning. So.
Oh, okay. Well,
Just an
let's
FYI.
cross our fingers.
Yeah, that's true. Okay.
The only other thing you can get computers to work is like to throw them on the floor and see what happens.
Stomping on them helps.
Yeah.
Okay. Thank you, Judge.
All right, thank you. All right, so Tilden, I'm just waiting on the paperwork for Mr. Roberts.
Judge, if you have time, can I see you in breakout room 1?
All right, everyone just give me a moment. Mr. Ryan, I'm going to send you to a breakout room with your attorney. I'm going to send you to breakout room number 1.
Yes, ma'am.
And Tilden Schaefer, we are ready on your client. Who's the prosecutor who's on this?
Jordan Brown.
Mr. Roberts, you need to start your video. Ah, there you are. All right, I need you to unmute for me, please. Court is calling 2020 CR 5937, State of Texas versus Marquise Jamal Roberts. Can I have parties announced for the record, please?
Gordon Brown for the state.
For the defense?
Tilden Schaefer.
And are you Mr. Roberts?
Yes, ma'am.
We're proceeding by video because of the pandemic. Any objections from the state?
Objection.
Defense, any objections?
No, Your Honor.
Mr. Roberts, I'm showing you what's entitled Defendant's Consent to Appear by Video. Did you review that document with your attorney? Did you
Yes, ma'am.
understand it and did you electronically sign it?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled Motion to Revoke Community Supervision and First Amendment Motion to Revoke Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Marquise Jamal Roberts who was placed on community supervision in 2020 CR 5937 for the offense of possession of a controlled substance, penalty group 1, less than 1 gram, on September 30th, 2020 for a term of 4 years? We're going to go off the record for a moment. This motion to revoke is not correct.
No,
Let me see you all in the breakout room. If you'll remain here, Mr. Roberts,
Yes, ma'am.
and state, if I could see you, if you go back to breakout room number 5, please. And Rebecca, if I could see you in breakout room number 5, please.
Hey, Marcus, he's okay with that. Would we be doing that today as well? And just if he, option A, if he's a candidate for drug court, he goes into drug court and follows recommendations. If denied from drug court, he's ordered to go to safety. Is there some way to do that today?
Yeah, we'll do it today.
Sounds good. Thanks.
It's close. Officer Harry, remember he was okay with the 4 months in jail?
It's not closed yet.
Okay, okay.
I'm waiting for them to misdemeanor
Okay.
stuff. But yes.
All right, everyone coming back from the breakout room, please remember to unmute. Mr. Roberts, you need to show your video. There we are. And Brenna, I'm so sorry. I forgot to add you to the spotlight. I know it's easier for you this way, so please forgive me.
That's okay.
All right, so we're going to go back on the record in 2020 CR 5937, State of Texas versus Marquise Jamal Roberts. We went off the record to have a conference in the breakout room. State, are there any motions?
Yes, Judge. The state has been made aware that there's a typographical error in the motion as filed. It alleges that this is a possession less than a gram. However, it is not, as a possession penalty of 1 to 200, and the state is requesting that change be made to the original and amended motions in the court's copies.
Any objections from the defense?
No objection from defense, Your Honor.
All right, then Mr. Roberts, I'm showing you, I'll grant that, and the court is showing you 2 motions. Again, it's entitled Motion to Revoke Community Supervision and First Amendment Motion to Revoke Community Supervision. Did you have a chance to review those documents with your attorney, and did you understand them?
Yes, ma'am.
Okay, are you the same Marquise Jamal Roberts who was placed on community supervision in 2020 CR 5937 for the offense of possession of a controlled substance, penalty group 1, 4 to 200 grams on September 30th, 2020 for a term of 4 years? Is that you?
Yes, ma'am.
All right, state.
Violating condition number 1, on or about the 25th day of October 2020 in Bexar County, Texas, the defendant Marquise Jamal Roberts committed the offense of possession controlled substance PG2A in violation of condition number 1.
How do you plead to that, true or not true?
True.
Right, state.
One more, violating condition number 37 in Bexar County, Texas, the defendant Marquise Jamal Roberts then there failed to report to the supervision officer as directed for the weeks of October 5 to 9, 12 to 16, and 19 to 23, 2020 in violation of condition number 37.
How do you plead to that, true or not true?
Not true. I haven't spoken to my probation officer, but I did call every week, every day, and leave voicemails. I wasn't contacted until at least a month afterwards.
All right, let me explain to you. Violation of condition number 37 says that you failed to report. So is that true or not true?
If I could interject, Judge, briefly.
Yes.
So Marquise, basically what's going on here is, this is part of our deal. In reporting on probation, it's incumbent on you to report whether you can't leave a voicemail. Voicemail doesn't count. I know you might have been trying. So what we're going to be doing is pleading true. You didn't report, but you have an explanation. Okay.
Okay.
So if you're comfortable, that's what we talked about.
That's
So
true
is it
then,
true?
Judge.
All right. Are you sure with the true for 37?
Yes, ma'am.
All right. State.
State would waive the remaining allegations, Judge.
Any objections to the state's waivers?
No, Your Honor.
Mr. Roberts, did you understand by pleading true to violations of conditions 1 and 37, the court could find it true, grant the motion, sentence you to 2 years in the prison and $1,000 fine? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of conditions 1 and 37?
Yes, ma'am.
The court will find violations of conditions 1 and 37 true. Is there an agreement?
No, Judge. In exchange for his plea, we are agreeing to TIC 3 cases. However, we are not in agreement on the disposition. The 3 cases are the one he pled true to, which is misdemeanor county court 649295, as well as the 2 allegations on the amended motion that he did not plead true to. Those are Night Magistrate 601652 and 601651.
That is correct, Your Honor.
As
All
far
right.
as disposition, Judge, the state is requesting a revocation as he was already assessed the minimum and convicted. The state is simply requesting that he receive the 2 years to do. The defense, I believe, is requesting reinstatement, and obviously he's got his explanation and their argument.
All right, defense, what are you requesting?
Judge, we're requesting reinstatement and along the lines of what the probation office put in their report. And basically they're asking for an 18-month extension, and they are asking for inpatient. It looks like safe P. I would suggest maybe SATIF might suffice in this or solve the issues. My client would like to address the court briefly and explain his situation.
All right. Mr. Roberts, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. Defense, did you want to do this in question and answer?
Judge, if he could allocate directly, that might be more effective, but I can start with question and answer.
Okay, you may proceed.
So, Mr. Roberts, can you explain to the judge why it is that you want to remain on probation as opposed to going to prison?
Because my initial point of even taking the probation was to get a change and make a difference. I understand that I put myself in positions to put myself back in jail, obviously, and the people who I chose to hang around wasn't very good choices. But I also want to take that challenge and reinstatement because I do want to change. I do want a difference.
Why do you want to change?
Mainly because I do have a 4-year-old little girl.
Okay, well, what's different now than back in October or November when you picked up the misdemeanor, and then back in February and you picked up new cases?
The difference would be, I guess, the determination for finishing this and completing this.
And determination for you or your family, or for who?
For me and my family, because a lot has changed since then, even though it's such a short time. Things came up to where I didn't know this whole time I was being put on child support, but apparently I just got that notification a couple days ago. And so that just kind of changed a lot.
Okay, so changed a lot. And what do you mean by changed a lot?
Basically, the reason to stay committed to this probation and stay committed to making a change, not only for myself, but for my daughter.
Okay. No further questions, Judge.
I have a few questions.
Sure.
One, your daughter is 4. She's not a newborn. So when you were on probation out of this court, and I put you on probation, your daughter was already existing in the world.
Mm-hmm. Yes, ma'am.
And this whole thing about you hanging around with people, the number one you pled to was possession. So that means that it was in your possession. So really it has nothing to do with hanging around people. And I'm looking at the conditions I gave you, and the conditions I gave you would obtain your GED, do drug testing, get employment, and you had a 10 p.m. curfew. So what I would like to know, this new number one that you pled true to, what time did that occur?
That I don't recall the exact time of that, ma'am.
Does anybody know what time that was?
Judge, I can access that information. It will take me a couple minutes to download it. But if you want to move on to another matter and recall this, I should have that in just a couple minutes.
Oh, no, I have more questions for Mr.
Okay.
Roberts.
I will start doing that now, and I'll let you know as soon as I have the answer.
So, Mr. Roberts, why should I continue you? And let me just tell you, when I say why should I continue you, I mean, what have you done specifically that means that you should be continued? So I don't want to hear, I need to be continued so I can support my daughter, because you should have been doing that. And you're telling me you were shocked you were on child support, which I don't understand the shock by that. You have a child, you're supposed to financially, emotionally, and mentally support them.
In which I have been doing,
So-
ma'am. Like I said, that's why I was
So
shocked.
why should you be continued? The only thing that you've done on probation for me is pick up new cases. When really on probation, if you were truly changing your life, there really should be only maybe 3 things you're doing. 1, following conditions of probation. 2, being employed. And 3, spending time with your child.
Well, ma'am, I was employed. I did get a job. I was working for Evergreen Landscaping. And I was also working on getting my GED. I was just trying to find, I was in the motion of trying to find the best place and how to go about finding the best place. And with my schedule with working all day and then having the curfew, it was kind of a little difficult.
No, it wasn't, because in conditions I wrote, your curfew was 10 p.m., excused if at work. So that wasn't the issue. So I'm trying to figure out, where did you find time to meet somebody to possess drugs?
Well, honestly, it wasn't finding time to meet someone. I was with this person before, and it was more or less like a place of living type of situation. So, and to be able to be in by a certain curfew, I would have to have a place to live, and that's where I was living at the moment.
That still doesn't excuse the possession of drugs. That's all 100% you possessing drugs.
Yes,
So
ma'am, I
again, we're
understand.
back to the point, like, why should I give you probation? Why should I continue you?
Because I do realize that I was wrong. I messed up.
I mean, people always realize that. Let me explain something to you. People must stop acting as though the world owes them something just because they're here. There are so many people who are on this screen right now who haven't picked up any criminal cases. And I don't know why people act like the world is so hard. You know what was hard? Slavery is hard, where people are not allowed to be educated, where people have to work sun up to sundown in the field. That's hard. You get a free education. Last time I checked, elementary school, middle school, when I was growing up, they called it junior high, high school, that's all free. Has something changed in the world where that's not free?
No, ma'am.
And then people need to stop blaming their experience on the fact that they had horrible parents. Everybody, I'm sure, has had something that has happened in their childhood that was not perfect. At some point, you become of age where all your choices are your own. They're no longer your parents' choices. And basically, what you have done with your life so far has been horrible. The example that you've been setting for your 4-year-old has been horrible, because you're not bringing anything to the table except for criminal history and continued drug use. And even though I've been trying to help you by giving you conditions, you still continue on this path. The fact that I have to tell people to get a job, that's insanity. People should know they need to get a job. The fact that you're working at a lawn company or making minimum wage, that's all you. You don't even have a high school diploma. How far did you go in school?
The 9th grade.
Why? I'm sure I've asked you this before, but why did you only go to the 9th grade?
I went to high school in Georgia and I was expelled for excessive tardiness, I believe. And then I was arrested after that. After that, I was moved states. My family didn't want nothing to do with me, so I moved to Virginia. And getting my paperwork from my dad, which was very difficult, never happened until I was grown.
All right, so I'm sure you're saying your parents didn't want anything to do with you. Well, either you had horrible parents, or either there was something you were doing and they just threw their hands up and said, we can't handle you anymore.
That would be the case, ma'am.
So what was it? They threw their hands up and said, we can't handle you anymore?
Yes, ma'am.
All right, so don't come to me with this sob story like your parents put you on the streets or somewhere like David Copperfield, where you had some orphanage saying, please, sir, may I have some more? You understand? Probation, what has he been doing?
Well, he hasn't performed any of his community service hours. No, he hasn't completed anything, Judge.
There you go. So you haven't been doing anything except for getting a new drug case. And according to you, hanging out with the wrong people, which if I were to talk to these wrong people, they would say that you're the wrong person. So what is probation's recommendation on this case?
Judge, I can read from the summary.
Sure.
They are alternative recommendations. One is revocation, and the other is the intermediate sanction facility, followed by intensive outpatient treatment and compliance hearing 6 months after release from ISF, are the two that their court summary shows.
All right. Well, here are your choices, Mr. Roberts, because hopefully your four-year-old daughter will have a male figure in her life that she can look up to. Right now, you've been a horrible parent to her. You have not given her any type of good example to follow. Based upon your actions, what she's learned is give your parents problems, don't graduate from school, and do drugs. That's all you've taught her so far. So here are your choices. One, I can follow probation's recommendation. That means you will do cognitive and the substantive abuse track with ISF. That's 180 days. There's a wait time for that. So you'd be waiting in jail to go to that. And after you were released from that, I will put you in felony drug court, and felony drug court is a 2-year program. So you can do those things, or I can revoke you and give you your 2 years down. So which would you like to do, or would you like to confer with your attorney?
Can I confer with my attorney, please?
Sure. Mr. Schaefer, you're in breakout room number 5. And Mr. Roberts, if you'll go back to breakout room number 5, please. And while he does that, just a moment. Was Raphael Leal here? Who are the parties on Ibarra?
Marcus and
That would
Vivian.
be Vivian Caceres for the defense, Judge.
All right. While they are considering things in the breakout room, then we'll take up that matter.
Okay, thank you, Judge.
You're welcome. Court is calling 2020 CR 9623, State of Texas versus Mark Wayne Ibarra. Can I have parties announced for the record, please, for the state,
Marcus Sanders.
for the defense?
Vivian Caceres.
Are you Mr. Ibarra?
I am.
Yes, you probably need to pull the mask up over your nose. I don't think it works if it isn't covered. We're proceeding by video because of the pandemic. Any objections from the defense?
No objections, Your Honor.
Any objections from the state?
No objection.
Mr. Ibarra, I'm showing you a document entitled Defendant's Consent to Appear by Video. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, I did.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Counsel, I'm showing you what's entitled Acknowledgement of Discovery. Have you received all the discovery in this case, and did you review it with your client?
I did, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Ibarra, I'm showing you a document entitled True Bill of Indictment. Did you review that document with your attorney, and did you understand it?
Yes, ma'am. Yes, I did.
Counsel, do you waive the reading of the indictment?
We waive it, Judge.
State, are you proceeding on the indictment as presented?
Yes, Judge.
So you're proceeding on the repeater offender
No.
enhancement allegations?
Oh, no, sorry, Judge. I didn't realize it was repeater. We are waiving the repeater enhancement.
Any objections to the waivers?
No objections, Your Honor.
All right, Mr. Ibarra, I'm showing you a document entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Did you understand what you're charged with is theft under $2,500 enhanced? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, I do.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, I did.
Counsel, has your client been able to provide you with any defenses to this offense?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Ibarra, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea bargain agreement?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
I'm very satisfied.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Next, I'm showing you the plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, ma'am. Yes, I did.
According to the plea bargain agreement, the state is asking that your punishment be assessed at 35 days in the Bexar County Jail under 12.44 of the Penal Code. There are no applications for community supervision or deferred adjudication, and the state will take in consideration County Court Cause number 656708. Mr. Ibarra, did you understand that to be the plea bargain agreement?
Yes, Your Honor, I did.
Defense, is that the plea bargain agreement?
It is, Your Honor.
State, is that the plea bargain agreement?
Yes, Judge.
Mr. Ibarra, I'm showing you the paragraph entitled Waiver Repeal. Did you review that paragraph with your attorney? Did you understand it? And did you electronically sign it in both places?
Yes, ma'am, I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor, I did.
Counsel, have there been any such motions?
No, Judge.
Then to the offense and the indictment, how do you plead? Guilty, not guilty, or no contest, Mr. Ibarra?
I plead no contest.
State any evidence to support the defendant's plea?
Yes, the state offers State's Exhibit 1 and its attachments.
No objections, Judge.
Mr. Ibarra, I'm going to show you a document entitled Waiver and Consent to Stipulations of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
Yes, Your Honor, I did.
Again, did you understand you have a right to jury trial, a right for
Yes.
you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, Your Honor, I did.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony.
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
We are, Your Honor.
Is there anything you wish to say on behalf of your client?
Just, we would respectfully request, Judge, that you follow the plea bargain we have in place, Judge.
All right, then the court will follow the plea bargain agreement that has been reached. The court will sentence you to 35 days in the Bexar County Jail under 12.44 of the Penal Code, taking consideration County Court Cause number 656708, and give you credit for any time served. Is this to be a judgment satisfied?
Yes, that's our intention.
All right, the court will find that the judgment is satisfied. Mr. Ibarra, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, Your Honor, I did, and I understood it, and yes, I signed it.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor, I do.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
All right, with that, we'll go off the record. Mr. Ibarra, I understand that times are hard for everyone, but this is not the way to solve your issue. There are plenty of help you can get from the homeless shelters, churches. All the churches have food pantries. You understand?
Yes, I do.
All right, good luck to you.
Thank you, Your Honor.
You're welcome. Norma, can you let 16D can go back? Mr. Schaefer, are we ready on your client, Mr. Roberts?
We are, Your Honor.
Later on today.
Yeah.
All right, everyone, if you're not a part of this hearing, I need you to mute. All right, we're back on the record, and cause number 2020 CR 5937. Mr. Schaefer, have you and your client had a chance to confer?
Yes, Judge, and he's opted for the 2 years TDC.
All right. Mr. Roberts, can you unmute for me, please? Are you requesting to be sentenced to 2 years in the prison?
Yes.
All right, then the court will grant the motion. The court will sentence you to 2 years in the prison, $1,000 fine, time and money will run concurrent, give you credit for any time served. Is there anything else with regards to sentencing?
No, Your Honor.
All right, Mr. Roberts, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney, and did you understand it?
Yes, ma'am.
All right. This was not a plea bargaining case. You do have a limited right to appeal, and that right to appeal is as it relates to the allegations in the motion and not the fact that you were on probation. Do you understand?
Yes, ma'am.
All right, Mr. Roberts, good luck to you. I hope that you make better choices in the future, if not for you, then for your daughter. You understand?
Yes, ma'am.
All right, good luck to you. And I'm sorry, just 1 second, Mr. Roberts, before you go, Brenna. I previously stated this on the record when you entered your plea, but just so that you can be doubly aware, because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. You understand?
Yes, ma'am.
All right, good luck to you.
Maybe excuse, Your Honor.
Yes. And Norma, can you let them know that 14B can go back?
Judge,
All
may I
right.
be excused?
Yes.
Thank you.
Thank you. Colin Hobbs, what are we doing with your case?
Judge, we're working through the paperwork. I'm waiting on the actual plea agreement from Marcus. I've gotten everything else thus far. I do think this client will need to be magistrated on the waiver number.
Okay.
And if you could make a note on the court's file appointing me to this one as well. Marcus did send me some of the offense reports and stuff, but obviously I have not had a chance to download any videos. But my client and I have talked about the case, and we would be comfortable moving forward today.
All right, great. To the courtroom. Just one moment. All right, in which case will he need to be magistrated on, Mr. Hobbs?
It's the new jail case. I think that's going to be 2021 CR 2793W. 2793W.
And Norma, I just sent you a chat.
Yes, ma'am, I just got it.
All right, thank you. And everyone, we're going to be taking our break at noon. And Norma, can you check to see if Eric DeWalt is the attorney for all of Mr. Conkey's cases?
Yes, ma'am.
I thought. Brenda,
Yes,
I
ma'am.
said what I should not have said. I think I may have jinxed us.
Oh,
I'm sorry.
it'll be okay.
Yeah. All right, Norma, for some reason, Raphael Leal was here and then he's no longer here.
Okay, I will give him a call, Judge.
Thank you. And does anyone have an update on what is happening with Mr. Hernandez?
Judge, the plea paperwork is still in the jail's email. I sent a chat to the defense attorney.
Yes, Your Honor, we seem to have some issues receiving the documents. They're not showing up in the email at the jail, but we're working on it.
All right, thank you.
I just sent a reminder too, so they should pop up again.
Mr. Lozano, you need to stay seated.
I was just gonna get some water, ma'am.
Oh, okay. All right, then just make sure you come back.
Yes, ma'am.
Yes, Stephen, you're back.
I am, and Mr. Hernandez, I believe, has signed all the documents, and we're ready when you're ready.
Well, as soon as they swear him in and tell me that they have all the documents, we will proceed.
We're missing the plea packet still. Do you know if you signed it? We have everything else.
All right, so Robert, if you'll go to breakout room number 3.
Okay.
And Norman, can I send you to breakout room number 3 because this paperwork is still in the defendant's box?
Yes, ma'am.
And Stephen Nichols and Valerie Fisher, if you go back to breakout room number 3, please.
Yes, Your Honor.
Yes, ma'am.
Brenda, do you know someone went to Galapagos Island? It's hard to talk with this in my mouth. And they stole over 185 baby turtles, wrapped each one of them in plastic. Can you imagine how hard it was for those turtles to breathe?
Yeah.
And taking it from that island, messing up the balance of nature.
Judge, can you put Joe Ray in the breakout room with us, please?
Yes. Joe Ray, can you go to breakout room number 3, please?
Yes.
But yeah, all of them wrapped up, Brenna.
That's awful.
And I was just like, oh my goodness.
Judge, can you enable the share screen, please, or come into the
It
breakout room?
is.
Enable it.
All right, I'll come to the breakout room.
Thank you.
Hey, Norma, on Thomas Ryan, are you able to see if he signed everything?
She may be in a breakout room.
Oh, okay. No worries. Thank you.
All right, so if you'll go back to breakout room number 3 now. All right, everyone, give me a moment. All right, and then we're just waiting for the paperwork on Ryan.
Judge, I think that we've both signed it all. If the clerk or the court can check on it, just to make sure. There might be one we're missing, is why I say it that way. And if so, if they could send a reminder email to send it over to the jail, that'd be helpful.
Is he only pleading to one case?
Judge, I think we're going to be moving forward to the MTR on one, and then yes, on the waiver one that I need him arraigned on, we'll be moving forward on that, and then there will be a TIC on the drug case.
All right, let's do this. Can you have your client come to the main room? And what I'll do is I'll magistrate him.
Yes, Your Honor.
And then we can send him back to the room, and then the clerk will see if they have all the paperwork.
Absolutely. Thanks, Judge.
You're welcome.
Okay, Judge, we're back.
All right, thank you. Brenda, we're not on the record for this.
Okay.
And Raphael has Mr.
Osama, Your Honor.
Yes. So I'll send you to breakout room number 1. And if a prosecutor can meet with Mr. Leal in breakout room number 1. And everyone, just give me a moment. Mr. Ryan, can you unmute for me, please?
Yes, ma'am.
All right, Mr. Ryan, I'm going to magistrate you on cause number 2021 CR 2793W. This is just me telling you what your rights are. I don't know anything regarding the facts of the case. Do you understand?
Yes, ma'am.
So you're charged with theft $2,500 to $30,000. You have a right to remain silent. You have a right to hire an attorney or have an attorney appointed to you. If you are indigent, you may request a court-appointed attorney. Once an attorney is appointed to you or you retained attorney, you will have reasonable time to consult with your attorney. If you decide to have an interview with any member of the state or a peace officer or police officer, you have a right to have your attorney present during that interview. Once you start an interview with anyone from the state or with a peace officer, you can stop or terminate that interview at any time. You are not required to give a statement to anyone. However, if you do give a statement, that statement could and may be used against you at trial or in court. You have a right to have an examining trial. If you are a foreign national, you have a right to have access to your consulate. If you desire to have a court-appointed attorney, what will end up happening is you will have to fill out an application. Based upon that application, there will be a determination made on whether or not you're indigent. If you need help filling out that application, a clerk will help you fill out that application, but that application must be sworn to. If you are appointed an attorney, that attorney must contact you by the end of the business day after that appointment. So if it is an attorney is appointed to you today at 11:51 a.m., then that attorney must contact you by tomorrow by 11:51 a.m. Are you requesting a court-appointed attorney?
Ma'am, I have Mr. Hobbs already.
And is he court-appointed?
I
Yes,
am.
ma'am.
All right. All right, what will happen is this document will be faxed to you. And the court coordinator will fax it to you so that you can sign it. Again, it is not you admitting to anything or the facts of the case. Your signature just signifies that I've gone over these rights with you and that you understand them. Do you have any questions about the rights that I've gone over with you?
No, ma'am.
Okay. And then Colin, I'll send you to breakout room number 3. Could the clerk go back to breakout room number 3, please? And they'll see if they have all your paperwork.
Thank you, Judge.
All right, and is there a prosecutor available to speak with Rafael Leal on Rodolfo Lozano? He's in breakout room number 1.
Sure, Judge, I'll go do it.
Corporal Cortinas, we had some computer technicalities, so we're trying to get Lozano signed back on.
All right, thank you.
Okay, thank you.
And Norma, do we have Cheyenne Yin?
Judge, I'm going to send you a chat.
All right, thank you. So on Cheyenne Yin and also on John Disrud client, Joe Julian Martinez, please. And Stephen Nichols?
Yes, Miss Ma'am.
Is your client only pleading to your case?
Yes, the other case will be dismissed.
All right, Mr. Who's the prosecutor on this?
Joe Ray, Judge.
All right, the court is calling 2020 CR 11194, State of Texas versus Glennie Hernandez. Can I have the parties announced for the record, please, for the state?
Ray Garcia for the state.
For the
Stephen
defense?
Stephen Nicholas for defendant Glennie Hernandez.
All right, we're proceeding by video because of the pandemic. Any objections from the state or the defense?
No, Your Honor.
No objection, Your Honor.
Mr. Hernandez, I'm showing you a document entitled Defendant's Consent to Appear by Video. Did you review that document with your attorney? Did you understand it, and did you electronically sign it?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled Application for Community Supervision. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
I have, and I have reviewed it with my client.
Court will find that the state is in compliance with discovery. Mr. Hernandez, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney, and did you understand it?
Yes, ma'am.
What's your name, bro?
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Mr. Hernandez, I'm showing you what's entitled Court's Admonishment and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it, and did you electronically sign it in all the appropriate places?
Yes, ma'am.
Do you understand what you're charged with is assault family second offense? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Just one moment, everyone. Is he pleading to 2 cases?
Just one, Judge.
Just one, Judge.
All right, for some reason, I've gotten a second plea packet from him. All right. All right, did you understand if you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement? If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do to both, Your Honor.
Mr. Hernandez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am. Absolutely.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Next, I'm showing you the plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 3 years in the prison. There's a $1,000 fine that will be probated. State recommends community supervision. They will dismiss 2021 CR 0828. There's to be no contact with Monica Aguilar, and there's an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
So is there anything else?
Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
It is, Your Honor.
State, is that the plea bargain agreement?
Yes, Your Honor.
Off the record, could someone visit with Mr. DeWalt in breakout room number 3 on Mr. Conte?
Matthew Rodriguez?
Next, I'm showing you the paragraph entitled Waiver of Appeal. Did you review that paragraph with your attorney? Did you understand it? And did you electronically sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motion?
No, Your Honor.
Next, I'm showing you outside the plea bargaining agreement, the state is requesting that your community supervision be for a term of 4 years. There be 100 hours of community service restitution. The BIPP course, random UAs, and $100 to an approved family violence center. Did you understand that those are recommendations from the state? The court does not have to follow those recommendations.
Yes, ma'am.
And to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's plea.
State offers State's Exhibit 1 and all its attachments.
Any objections?
No objections, Your Honor.
Mr. Hernandez, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial? A right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent.
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements, police reports, and judgments, but most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same.
What's up with you?
Fernando Vargas, estaba como just stuck to the judge. Come on. I already signed the papers and all. Fernando Vargas, what unit are you in? 931. No, what unit? What unit?
After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Is there anything you wish to say on behalf of your client?
Think he's learned his lesson. I think it's appropriate to place him on probation, and I wish for you to follow the plea bargain agreement, Your Honor.
Mr. Hernandez, do you have any children?
Yes, ma'am. I have 3.
What are their ages?
16, 21, and 22.
All right. Has Child Protective Services been involved in your life?
No, ma'am.
When's the last time you had employment?
Before my incarceration.
Doing what?
Concrete. I have many skilled trades, ma'am.
When's the last time you had contact with Monica Aguilar?
The last time I had contact with her was about 7 months ago.
Is there any drug issues?
I've been off and on drugs in the past. I do not plan on using any drugs or wish of going back to any drugs.
What type of drugs have you been using in the past?
Marijuana and heroin.
All right. Okay, this is what the court is going to do. The court is going to sentence you to 3 years in the prison, suspended and probated for 4 years. There's a $1,000 fine that will be probated. Dismiss cause number 2021 CR 0828. No contact with Monica Aguilar. Affirmative finding of family violence. Proof of employment within 15 days. There's to be no employment with vulnerable persons. That means you're not allowed to work with children. So you can't be a babysitter or work at a daycare. And you're not allowed to work as a home health care provider or in any field involving the elderly. Outpatient treatment with probation, the BIPP course, parenting classes, random UAs, I'm going to want random field visits, but at least once a month. $100 to an approved family violence center. Mr. Hernandez, are you able to Zoom or no?
Yes, ma'am.
All right, there'll be regular reporting by Zoom or in person. Mr. Hernandez, is there anything else you need from the court to be successful on this probation?
No, ma'am, I feel everything that all my stipulations that y'all are giving me will be good enough for me to be able to continue living a successful life and be a positive influence on my community.
All right. Rebecca, is there anything else that he needs?
No, ma'am.
All right, Mr. Hernandez, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is a family violence case and there was an affirmative finding of family violence, and also because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
All right, with that, I'm going to send you to breakout room number 4. Probation will be there with you shortly to go over your conditions with you. Do you understand?
Yes, ma'am.
All right, let me just find you. Just wait patiently. She'll be there with you. And defense, you can go to breakout room number 4 or you are excused.
May I be excused, Your Honor? Is that okay, Glenn?
Yes.
Yes, sir. Thank you very much. I
All right,
appreciate
Mr.
everything.
Hernandez, if you'll go to the
You're
breakout
welcome.
room, please.
Thank you, Valerie.
Thank you, Stephen.
Who is the prosecutor on Ryan?
It was Marcus, Your Honor.
All right, Mr. Hernandez, go to the breakout room. Look at the bottom of your screen. Do you see boxes that say breakout room?
Yes, ma'am.
All right, click on that and go to the breakout room.
Okay. Yes, ma'am. Thank you.
Your Honor, may I join a breakout room with my client, Mr. Conkey?
Yes.
Thank you. And I apologize for jumping on and off. My apologies.
No problem. Eric DeWalt, I'll send you to breakout room. Let me see where you are. If you'll go back to breakout room number 3, and Mr. Conkey, if you'll go to 3.
Your Honor, could you also place recall docket Rudolfo Lozano in breakout room 1, please? I think he's in custody.
Mr. Lozano, if you'll go to breakout room number 1, please.
Yes, ma'am.
And Mr. DeWalt, if you'll just go back to your previous breakout room.
On an iPad, how do y'all normally send me over there? And I'm trying
No,
to
you
look
should see where it says breakout room. And then if you just click on the boxes, the 4 boxes at the bottom. I tell you what, let me do this. I'll make it easy. I'm going to send you to breakout room number 6.
Okay, thank you.
All right. Court is calling 2021 CR 2793W, State of Texas versus Thomas David Ryan. Mr. Ryan, if you could unmute for me, please. Fab parties announced for the record, please, for the state,
Marcus Sanders.
for the defense.
Colin Hobbs for Mr. Ryan.
Right. We're proceeding by video because of the pandemic. Any objections from the state?
No objection.
Defense?
No objection, Your Honor.
Mr. Ryan, I'm showing you a document entitled Defendant's Consent to Appear by Video. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm going to show you a document entitled Waiver of Indictment, Reading of Information and Rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Did you understand you have a right to have a grand jury hear the evidence in this case and make a decision on whether or not to indict?
Yes, ma'am.
Did you also understand your attorney has certain rights, namely 2 days from the presentation of the information and 10 days from the presentation of the information to prepare for trial? Did you understand?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Next, I'm showing you the document entitled Information. Did you review that document with your attorney and did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the information?
We do, Your Honor.
State, are you proceeding on the information as presented?
Yes, we are.
Counsel, I'm showing you what's entitled Discovery Acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Judge, in this particular case, I discussed it with my client. Marcus was kind enough to send me offense reports last week, which I have reviewed. Obviously, with the fact that I was just appointed on this case today, there are videos that are listed, which I've not had an opportunity to download and review. However, I have discussed that with my client, and based on our conversations regarding the offense report and his recollection of events, he's perfectly comfortable with us moving forward today without me having an opportunity to download and review those.
Okay, and defense counsel, are you asking the court to proceed with this plea and sentencing today?
Yes, Your Honor.
Mr. Ryan, you've heard what your attorney has informed the court of. Are you asking that the court proceed with this plea and sentencing today?
Yes, ma'am, please.
You do understand if you wanted extra time or desired extra time before entering this plea, that the court will give you that extra time. Did you understand?
Yes, ma'am.
And knowing that you still wish to continue to go forward.
Yes, ma'am.
All right. Mr. Ryan, I'm showing you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
Yes, ma'am.
Did you understand what you're charged with? It's $2,500 to $30,000. That theft of $2,500 to $30,000. A state jail felony, the range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call them the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Good morning, everyone. My
I
name
do.
is Cynthia Gonzalez. We're going to get started.
Do you believe he's currently competent in what's legally saying at the time of the offense?
Yes, Your Honor.
Mr. Ryan, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am, I am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Next, I'm showing you the plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, ma'am.
According to the plea bargain agreement, the state is asking that you be assessed punishment under 12.44 of the penal code to 1 day in the Bexar County Jail, and there are no applications. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
It is, Your Honor.
State, is that the plea bargain agreement?
Yes, Judge.
Next, I'm showing you the paragraph entitled waiver of appeal. Did you review that paragraph with your attorney? Did you understand it? And did you electronically sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counselor, have there been any such motion?
No, Your Honor.
Then Mr. Ryan to the offense is charged in the information. How do you plead? Guilty, not guilty, or no contest?
No contest, no.
State any evidence to support the defendant's no contest plea.
It's the state offer states Exhibit 1 and its attachments.
No objection, Your Honor.
Mr. Ryan, I'm showing you a document entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you have a chance to review that document with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
Yes, ma'am.
And did you understand you have a right to jury trial, right, for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states Exhibits 1 and attachments, and the court will review the same. All right, after reviewing states Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. The court will follow your plea bargain agreement, sentence you to 1 day in the Bexar County Jail under 12.44 of the Penal Code. Court will give you credit for any time served, and the court will show that the judgment is satisfied. Next, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it, and did you electronically sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is a felony conviction, and you're not allowed to own or possess any weapons or ammunition, do you understand?
Yes, ma'am.
Court is calling 2020 CR 10721W. Again, we're proceeding by video because of the pandemic. Any objections from the state or the defense?
No objection.
No, Your Honor.
Mr. Ryan, I'm showing you what's entitled Defendant's Consent to Appear by Video. Did you review that document with your attorney? Did you understand it, and did you electronically sign it?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, Mr. Ryan, I'm showing you what's entitled Motion to Revoke Community Supervision and First Amendment Motion to Revoke Community Supervision. Did you review those documents with your attorney? Did you understand them?
Yes, ma'am.
Are you the same Thomas David Ryan who was placed on community supervision in 2020 CR 10721W for the offense of burglary or habitation on November 2nd, 2020 for a term of 6 years? Is that you?
Yes, ma'am.
State?
From the first amended motion, condition number 1, on or about the 21st day of February 2021, in Bexar County, Texas, the defendant Thomas David Ryan committed the offense of possession of a controlled substance in violation of condition number 1.
How do you plead to that? True or not true?
True, ma'am.
I'm sorry?
True.
Okay.
We'll
State?
waive the
Objection.
Mr. Ryan, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, sentence you to $1,000 fine and up to 6 years in prison? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court will find violation of condition number 1 true. Is there an agreement?
There is, Judge. We are asking that you deny the motion, alter and amend to refer the Mr. Ryan to felony drug court. If for some reason he isn't, I guess, able to get into felony drug court, we're asking that he be sent to SafeP. And we have agreed to TIC cause number Night Mag 603512 in consideration for his plea today.
And that is our understanding of the agreement, Your Honor.
All right, Mr. Ryan, are you requesting that the court follow this agreement?
Yes, ma'am.
All right, the court would deny the motion, alter and amend conditions. The defendant is to be referred to felony drug court. The defendant is to remain in custody while waiting referral or acceptance into felony drug court. If not accepted into felony drug court, then SafeP.
Thank you very much, Your Honor.
All right. If there's nothing else, we'll close the record on that case. Mr. Ryan, I'm going to send you to a breakout room. Probation will go over conditions with you. Mr. Hobbs, you can go to the breakout room with your client, or you can be excused.
Thomas, are you okay if I be excused?
Yes, sir, I'm good. Thank you.
All right, Rebecca, if you could go to breakout room number 4.
Yes, ma'am.
Might be excused, Your Honor.
Yes.
Thank you.
Oh,
Y'all have a
and-
great day. Thanks, Marcus.
Thank you. And everyone else, unless there's something ready to go right now, we're going to take a break and we'll come back at 1:45 because Brenda needs a
Your Honor,
break.
we have.
Judge, can I just give you an update?
Yes.
I was up for a PR bond for Mr. Conkey, and I have an agreement with the state to proceed on the 2 MTRs to dismiss the new number 1. So we have a plea on the MTRs, if that's okay with the court.
Yeah, if you'll let Norman know that, and we'll take care of it first thing when we come back after break.
Okay, thank you, Judge.
All right,
Just-
so that'll be 1:45. Mr. Leal,
We also ready on Rodolfo Lozano, Your Honor.
what is happening with that case?
We have an agreement with the state.
All right, see you back at 1:45.
Thank you, Judge.
All right, Mr. Lozano, we'll take your case up at 1:45.
Thank you, ma'am.
You're welcome. All right, everyone, we're going to take our break. And so we'll see everyone back at 1:45.